Okay, I think we're still waiting for the trooper, and then once he arrives, we will begin.
He is in the waiting room. Do you want me to pull him in?
Let me ask Ms. Muggenberg, are we ready to have him come in?
I believe so. Yes, Your Honor.
Let's do so. In the meantime, I'm going to call the case of People versus Andrew Sluter. This is a Wexford County case. It's file 22-13464FH. You're Mr. Sluter, correct?
Yeah.
All right. You can see and hear me. Is that right?
Yep.
Also with us today, we have Ms. Muggenberg. She's the prosecutor handling this matter. We have your attorney, Mr. Harrison. He's in the courthouse in Wexford County, along with the clerk's office. Also, we have Mr. Adam Whited, who's a trooper in this matter. And we have this matter set for bond violation hearing. Let me begin with you, Mr. Harrison. Are we going to proceed to a hearing on this matter?
It is my understanding that that is how we are going to proceed, Your Honor.
All right, let's go ahead
Yes.
and do so. Opening statement, Ms. Muggenberg.
Your Honor, very briefly, the allegations are that he committed additional crimes and did not cooperate with bond and was uncooperative with police officers while on bond. And that is why we have Trooper Whited here today. I believe he'll be able to testify to that. Thank you.
All right, thank you. Opening statement, Mr. Harrison.
Indeed, Your Honor, we have a series of allegations. There is no bond condition that Mr. Sluter is subject to that precludes him from being accused of any criminal behavior. These are not convictions, and he intends to contest the allegations which have arisen into actual criminal charges as well in a separate case. In I think 2 of the 3 actually are matters in Missaukee County.
All right, thank you. Let's go ahead and go to you, Ms. Muggenberg. If you call your first witness, please.
Thank you, Your Honor. The people called Trooper Adam Whited.
All right, Trooper, if you please raise your right hand. Do you solemnly swear or affirm the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, Ms. Muggenberg, you may proceed.
Thank you. Trooper, if you would start with your name and spell your last name for the record, please.
Trooper Adam Whited, W-H-I-T-E-D.
And which post are you working out of at this time?
I'm currently assigned to the Michigan State Police Houghton Lake Post.
And I want to draw your attention to January 5th going into January 6th. Were you working on the 5th?
Yes, ma'am.
And do you recall what shift you were working?
I was working a day shift.
At some point you got involved, or you were asked to become involved in a surveillance that the 7th District Fugitive Team was working on. Is that correct?
That's correct, yes.
Okay. Do you recall approximately what time that was?
I believe it was around 9 o'clock in the morning.
And who was the subject that was being sought?
Mr. Sluter.
Can you tell us how you became involved specifically?
I was actually headed to a training in the area of Cadillac with some other K-9 handlers. I'm a K-9 handler within the Michigan State Police. I was contacted by members of our emergency support team, which is our SWAT team, and advised that they had been requested by the fugitive team to assist with the apprehension of Mr. Sluter for a felony warrant that was being sworn to that morning.
Do you know what the warrant was for?
It was for criminal sexual conduct, 1st degree, I believe.
Objection, relevance.
As to relevance.
I'll move on, Your Honor. I just wanted the court to be aware that it was a felony and a serious felony.
Please proceed.
Thank you. So what happened at that point, Trooper?
I responded to the area where I made contact with the 7th District Fugitive Team. They had advised, they believed they had seen Mr. Sluter inside the residence at a computer. His location in that house was also confirmed by a court-ordered GPS monitor that was affixed to him. While they were doing surveillance, Mr. Sluter was observed by 7th District Fugitive Team members leaving that residence in a vehicle. and again, his GPS monitor was being actively monitored at that time, and it was further verified that that GPS monitor was moving with that vehicle. The fugitive team began following that vehicle to maintain surveillance of Mr. Sluder in that vehicle, at which point we were advised that felony warrant for Mr. Sluder had been authorized and signed, at which point they asked me to conduct a traffic stop to take Mr. Sluder into custody.
Did you attempt to do that?
Yes, ma'am. I attempted to make a traffic stop on Mr. Sluder on Mackinac Trail or old US 131 just south of Manton. I was in a fully marked patrol vehicle in uniform. Initially, Mr. Sluder's vehicle pulled to the right side of the road, but as I got behind that vehicle, as I was preparing to exit my vehicle, that vehicle then accelerated away from the traffic stop, at which point a pursuit was initiated. The pursuit went northbound on Mackinac Trail before turning eastbound onto M42. When Mr. Sluder was attempting to make that turn, I did attempt to utilize a pit maneuver to disable that vehicle, but that was unsuccessful.
Would you describe for us what that is?
The pit maneuver is short. Pit is short for precision immobilization technique. That's where we use our vehicle to basically create leverage to spin that vehicle around, and the motion of the vehicle rotating and being in gear is ideally supposed to disable that vehicle by shutting down the engine due to the resistance of the vehicle going from a forward to a reverse motion. Unfortunately, that was not successful. The vehicle then proceeded down M42 eastbound, at which point the vehicle's brake lights illuminated and rapidly decelerated. I was forced to avoid rear-ending the vehicle by going to the left around the vehicle, and then attempted to block the vehicle from continuing forward by positioning my vehicle in front of Mr. Sluder's vehicle at an angle. His vehicle made contact with my vehicle at that point and then proceeded around me, and the pursuit continued down M42 eastbound. The vehicle then made a turn onto the on-ramp to go onto US 131 south. Again, I attempted to set up for a pit maneuver at that time, which again was unsuccessful. The pursuit ended up going southbound on 131 all the way to the Boone Road exit, at which point the vehicle crossed the median and drove for a period of time in the opposite direction of oncoming traffic on US 131 before taking the what would have been the on-ramp for vehicles on Boone Road to exit onto US 131 northbound. Again,
Trooper, if I can, how fast was he going on 131, if you recall?
I know at points there were speeds exceeding 90 miles an hour. To give an exact number, I can't recall.
Okay. So go ahead. You said you had just gotten, or he had gone off the entrance ramp.
Yes, he had gone counterflow on US 131 and then went counterflow on traffic on what would have been the on-ramp from Boone Road to US 131. He then went eastbound again, this time on Boone Road or 34 Road. I continued to pursue him down this road to a T intersection, at which point he continued eastbound on a seasonal road. I continued to pursue him on this seasonal road for approximately a mile before he eventually came to a stop. He exited his vehicle. He was a short distance in front of my vehicle as we were coming to a stop, at which point I gave him commands that I was a K-9 officer and that I would be sending my dog if he did not stop.
The judge finally lays down the terms of Mr. Mattson's sentence. He receives 1 year of probation and 29 days in jail, with credit for the 29 days already served. But the court imposes strict conditions on alcohol and drug use, testing, and substance abuse treatment. The judge makes one thing very clear. This is his chance to comply, but if he violates probation, jail time will follow.
And then obviously he was continuing to run, so at which point I released my dog offline, so my dog and I are both running in his direction, and I was giving commands for my dog. When my dog apprehended Mr. Sluder, I gave commands for him to get on the ground. And as he went to the ground, he appeared to be fighting with my dog. So I gave commands for him to stop fighting my dog. As I continued to the dog's location and Mr. Sluder's location, that he now had the dog had apprehended him. He continued to appear to be fighting my dog with his left hand, as the dog had apprehended him by his right elbow area. I gave additional verbal commands for him to stop fighting my dog. And he appeared to have something in his hand, so I delivered hammer fist strikes to Mr. Sluder to get him to stop fighting my dog. I was able to get Mr. Sluder onto his stomach, at which point his left arm was still under his arm, so an additional hammer fist and commands for him to stop fighting the dog were given, at which point I was able to finally get his left hand behind his back. And proceeded to handcuff Mr. Sluder and take him into custody.
Thank you. No additional questions at this time, Your Honor.
Cross-examination, Mr. Harrison.
Indeed, Your Honor. Do you have any preference as to whether I remain seated?
Well, since we're at a bond hearing in multiple locations, seated is fine, sir. Please proceed.
Thank you. I didn't know what your preference was, and I didn't want to offend it inadvertently.
Thank you for asking. Please proceed.
Trooper, when you say he was apprehended by your dog, you mean the dog had bitten him and clamped onto his arm?
Yes, sir.
His right arm?
Correct.
So he was making an effort to get the dog to release his arm?
I can't attest to what his intention was. I could tell you that he appeared to be fighting my dog, whether that was to prevent the dog from biting or holding the dog in some way, but it appeared that he was fighting my dog.
Okay, and you gave the order for your dog to release his arm at some point?
Several times during that interaction, Mr. Sluder asked why the dog was biting him. I advised him multiple times to comply with my commands. And as soon as he would comply with my commands and I could secure Mr. Sluder in handcuffs, then the dog would come off. As soon as Mr. Sluder's hands were in handcuffs, I did move and release the dog from that bite, yes.
Okay, so the dog maintained its grip on Mr. Sluder's arm until he was handcuffed in that altercation that you described?
Yes, sir.
Okay. When you initially made a traffic stop, you mentioned it was over by just south of Banton. Does that familiarize you with the juncture of which I'm speaking?
Yes, sir.
Okay. No bad driving by Mr. Sluder at that point, correct?
Not that I had observed. The traffic stop was for the felony warrant that was authorized prior to my stop.
So he didn't have any missing equipment on his vehicle, and all the lights that are required appeared to be functioning. Is that correct?
Again, I wasn't following him very closely, to what I can recollect.
Yeah, I understand. Yeah. Okay. So when his vehicle came to a stop, you issued a series of command to a series of commands to your dog. Did you say anything to Mr. Sluder at that point?
As I exited my vehicle, I gave a command that I was to stop, for Mr. Sluder to stop, or I would be releasing my dog.
Okay. So, all right. I think I understand. Do you have any indication that Mr. Sluder heard you say that?
I do not. He was in the process of running as I was ordering those commands.
Okay. Thank you. No further questions, Your Honor. Thank
Any
you.
redirect?
When you did stop your vehicle, again, you're in your fully marked patrol vehicle, full uniform. Did you have lights and sirens going that entire time?
As the initial stop, I had my lights on. As soon as Mr. Sluder took off from that traffic stop, at that point, I activated my sirens, and they were activated along with my lights the entire duration of the pursuit. Our vehicles are designed when we place them in park, that those sirens will then shut off as well. So the siren was not going when I gave my announcement as I exited my vehicle either, to either cause an issue with the siren going and him being able to hear my command.
Okay, thank you. I have no additional questions, Your Honor.
Is there any recross?
Indeed not, Your Honor. Thank you.
All right, thank you. Mr. Sluder, did you wish to speak with your attorney? Is that what you were motioning for?
Yeah, I have some questions I'd like you to ask.
Stop. Okay. Let's go ahead and put them in a separate room, please, for just a moment. Okay, it appears that we have the defendant back along with his counsel. Is there any additional recross? Pardon me.
There is not, Your Honor, but I will call Mr. Sluder as a witness when I get the opportunity to do so.
All right, thank you. Ms. Muggenberg, any additional witnesses that you wish to present?
No, Your Honor, and I'd ask that we're done. Trooper White would be excused.
All right, without objection, Trooper White, you're excused. Thank you for your testimony. Let's go ahead and proceed then to the defense. Mr. Harrison, you wish to call any witnesses?
I do. I would call Mr. Sluder.
Okay, Mr. Sluder.
I am calling Mr. Sluder. I'm sorry.
All right, thank you, sir. Mr. Sluder, we'll get to swearing you in just a moment. I want to remind you, you have a absolute constitutional protection against making any statements here on the record with regard to this matter. I'm told that there may be criminal charges involving this matter. I don't know that, but that's at least been represented by your attorney and I think by the prosecutor as well. As a result, anything that you say here in court today could be used against you in a court of law. And if your attorney has an opportunity to question you on these matters, that would also mean that the prosecutor will have an opportunity to cross-examine on those issues. Do you understand that?
Yes, I do.
Have you had a chance to discuss the rights that you have, the absolute right not to testify and potentially incriminate yourself with your attorney?
Yes, I understand my rights, sir.
Do you have any questions for me about those rights?
No, I do not.
All right. In that case, please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
All right, Mr. Harrison, please.
Thank you, Your Honor. Mr. Sluder, I've already told everybody who you are, and I think everybody knows. But for the record, could you state your name and spell your last name for the clerk?
Andrew, Sluiter, as Sluder.
Okay. So, Mr. Sluder, do you recall the events of January 5th of this year?
Yes, I do.
In particular, what occurred that is of interest to the court here today?
Well, prior, I had made contact with a Sergeant Detective Bowman at the police department and state police department. He had contacted me concerning complaints of corruption in Wexford and Missaukee. So I filled out a police report with him on corruption that was taking place between the court system and my family over the last 4.5 years.
Okay. So you had you had made a complaint to the state police that there's certain activities were occurring that you believe constituted improper activity.
They were in violation of federal law, Clause 242, Title 18, and also in violation of interference with interstate commerce laws when they were illegally removing our kids.
Okay. Do you recall on January 5th having contact with a state police officer?
I don't believe I had contact with any state police officer prior to what took place on the 5th.
Okay. So on the 5th, what occurred?
On the 5th, I had woken up that morning. I called to do my drug test checking and to comply with my bond. I didn't have a drug test. I was in the process of getting a new job after I was fired from the last job because the state police had arrested me from my place of employment. I woke up that morning. I called for the drug test. I then started getting ready to go to a place where one of my friends had a friend that needed some help at his body shop.
Okay, and
So,
where was that? Where were you going?
That was a little body shop that's right outside of Manton, in the industrial park outside of Manton.
Gotcha.
I got up that morning and made some coffee, and my mom was at work on her computer, which was a Munson computer. And I told my mom that I was getting ready to leave and everything. And I ended up leaving. After I started getting down the road, I noticed there was a vehicle that was following me. It was an unmarked car. And I'd originally, the day before, I believe on either the 3rd or the 4th, I attempted to make a complaint with Wexford Sheriff's Department of people who were stalking me. And I ended up observing.
Was it your belief or understanding that the vehicle following you may have been involved in stalking activity?
It was.
Proceed forward, but you know what I'm getting at. I want to talk about, go ahead, Mr. Sluder.
So I continued driving. It was very icy out that morning. We had a ice storm the night before. The roads were bad. As I rounded the corner near the dump near Manton, there was an accident where somebody went off the road. There was a vehicle in front of me, myself, and the vehicle that was following me. And we pulled off the side of the road and slowed down. We were only going 45 top speed, going down the road, the icy roads, and we slowed down even further as we passed the police officers and the accident on the left side of the road. Approximately a mile up the road, I see a police car come flying up. And as soon as he got to the back of the vehicle behind me, he turned his lights on. And we pulled over to the right side of the road. It was the vehicle behind me, my vehicle, and the vehicle in front of me. We all pulled off to the side of the road, and the police officer turned his lights on, swooped around the vehicle that was behind me, and came straight into the back of my vehicle. And when I looked in my rear view mirror, he threw his door open, and he jumped out, and I seen him reach down for his gun, so I took off.
Okay.
Immediately after I took off, I called 911, and I asked what was going on. And they just told me that I had a warrant. And I said, for what? I've done nothing wrong. And they wouldn't tell me what a warrant was for. And I told them, you guys are just trying to kill me. They were slamming into the back of my vehicle. And it wasn't a pit maneuver. You hit the side of the vehicle. He was smashing into the entire back of my vehicle.
Okay. So you believe that you were in danger at this point?
Yes.
What was your objective? Where were you attempting to drive to?
I was trying to get away from them and get to safety.
What do you mean when you say get to safety? Where were you going?
I was trying to go to my father's house.
Where does your father live?
In Missaukee County.
Okay, so at the conclusion of this, were you therefore in Missaukee County?
I wasn't in Missaukee County at that point. I was in Wexford.
Oh, so the initial traffic stop, you're trying to get to safety. Did you make it to your father's house?
No, I did not.
Well, what happened then?
I had spoken with dispatch on the phone when we were going down the road because it was icy, and I'd asked dispatch to tell their officers to slow down and back off because there are other people on the roads, and it was dangerous in the situation with them riding and smashing into the back of my vehicle multiple times with other people around in their vehicles. And dispatch told me that they would not do that. So the police officers kept smashing into the back of my vehicle and kept forcing me to go faster to be able to stop them from trying to hurt me.
Well, eventually you did stop your vehicle then?
Yes, eventually I went off a 2-track because there was no people and I knew it would be safer for the public to be not on the roads with what they were trying to do to me.
Okay. Can you describe what happened at that point?
I ended up getting down towards the dead end of the 2-track and I put the vehicle in park and I got out and I took about 3 steps and I fell on the ice. And I got back up and I took about 3 more steps and I fell on the ice again. I heard the officer stop and he just yelled, "Stop." That's all I ever heard him ever say. And then the next thing I knew, I had a dog on my right arm. And the dog kept pulling at my arm. I tried to get the dog's mouth off my arm because it had bitten through my coat, my sweater, and my t-shirt into my arm. And it was biting onto one of my tendons.
Okay.
And
So after you heard the trooper say stop, what did you do?
I was already on the ground at that time. I wasn't running.
So you stopped.
Yeah, I was flat on my back on the ground.
Okay. And then is that the point at which the dog attached itself to your arm?
Yeah, I was on the ground when the dog attached.
Thank you. Thank you, Mr. Sluter. No further questions, Your Honor.
Cross-examination.
Thank you, Your Honor. So you saw, Mr. Sluter, in the back of your vehicle, there was a police car. You said that 3 cars pulled over. The trooper maneuvered so that he was directly behind your vehicle. And at that point, you fled. You took off.
I didn't take off until he stepped out and reached for his gun.
Okay, so he stepped out, put his hand towards his gun, and you took off. Okay, you understand that when a police officer pulls you over on the side of the road, and that way you're supposed to remain in your car and allow him to come talk to you. Is that right?
I understand a police officer is not
Yes or
allowed to
no?
pull you over. No.
And at some point you were talking to dispatch. You knew you had a warrant for your arrest, correct?
Yeah, into it.
And you continued to flee from the trooper.
Yeah.
And at times on 131, you sounds like you broke 90 miles an hour.
I'm not sure.
You use the entrance ramp to exit the expressway to get away from him.
After they forced me to.
No additional questions, Your Honor.
Is there any redirect?
I don't believe so, Your Honor. Thank you.
All right, thank you. Any additional witnesses, Mr. Harrison?
I have no further witnesses or proofs, Your Honor.
All right, Ms. Muggenberg, any rebuttal?
No, Your Honor, thank you.
Let's have some argument. We'll start with the people, please.
Your Honor, I would ask the court to revoke the defendant's bond. First of all, when we look at his bond conditions, he's not to commit any crimes while being released. Obviously, we're not going to consider the warrants that are out there, but basically today we had a trooper that testified, and to some extent a defendant that admitted to fleeing and eluding. He clearly, the officer is there. The officer wants to talk to him. The officer's in a fully marked patrol vehicle with lights and sirens in a full uniform. And when he pulls the defendant over, the defendant flees. Additionally, there's potentially an R&O there based on the testimony. Another section of the defendant's bond is no violent or
The judge makes it clear that Mr. Mattson has been given a chance to stay out of jail, but that opportunity comes with strict conditions. He must follow the court's rules, avoid alcohol and controlled substances, submit to testing, and complete the required treatment. The message from the court is simple: comply with probation or face more serious penalties, including jail time.
everyone else on the road that day. Again, especially given the charge that he is facing, this is just, but frankly, in his inability and from his testimony, his unwillingness to follow police instruction, because based on whatever beliefs he has basically told us today that he will not do that. That makes him extremely dangerous to the public. So I would ask the court at this time to revoke his bond. I believe we have a final conference coming up later this month, and we should proceed to trial at this point. But I believe, again, just in the safety of the public and himself, that he needs to be incarcerated.
All right, thank you. Let's go ahead and hear from Mr. Harrison, please.
Oh, indeed, Your Honor. Well, first of all, I agree, oddly, as it may sound, I agree with Ms. Mogenberg to the extent that the bond conditions to which Mr. Sluder is subject are not open to debate. He's not to commit any new crimes while on bond, and he's not to behave in a threatening manner. The problem, and I guess the disconnect I have with Mrs. Mogenberg's version of the story, is that he's innocent until proven guilty. These crimes are merely allegations at this point in time, and cannot constitute any sort of conviction based on those crimes. Obviously, as we've heard here today, there's some disagreement with regard to the sequence of events. Now, let's move on to prong 2. The threatening, assaultive, etc. behavior clause in the bond conditions. If anybody was behaving in a threatening manner on that day, it was the East State Police. They acted as though a gun was going to be employed. He, in the midst of learning about gathering more information, calling dispatch, learning the full extent of the situation, yes, he was driving away from the trooper at the time, but the trooper's the one that further added tension and threatened to the situation when he repeatedly rammed his vehicle up against Mr. Sluder's vehicle, whether it's the rear or this pit maneuver or whatever else he described. Lastly, when Mr. Sluder brought his vehicle to a stop and stopped at the request of the state trooper, he was further threatened and indeed was had an encounter with the K-9 officer. I think it's a bit of a stretch to regard Mr. Sluder's actions that day as being that of a threatening nature. I suppose I understand why this request was made, but I don't believe, even by the preponderance standard, that the allegations set forth in the request to revoke his bond have been suitably supported. Thank you, Your Honor.
Thank you, counsel. Any response, Ms. Muckenberg?
No, Your Honor, thank you.
All right, the question before the court is bond. Bond is reviewable at any time. The court set a bond hearing in order to hear whether there was evidence of a bond violation with regard to activity that apparently occurred on or about January 5th of 2023. We heard testimony from Trooper Adam Whited, who indicated that he was working the day shift on that date. He's a K-9 handler. He was assisting the, I think it was a fugitive task force. I may be wrong with the identification, but the SWAT team, yes, and the fugitive team, they were planning on picking up the defendant once a warrant came through. The warrant did apparently come through. At some point, at that point, the defendant was behind the wheel of a vehicle that the trooper got in behind the vehicle with his uniform on, with his fully marked vehicle, pulled over the defendant, and then as the trooper was getting out, the defendant fled away. The trooper attempted a pit maneuver in order to spin and disable the vehicle. It was not successful. There was acceleration and then rapid deceleration, during which the trooper was able to avoid ramming directly into the defendant's vehicle. But the defendant's vehicle got away from the trooper's vehicle at that point. After the defendant hit the trooper's vehicle, the defendant's vehicle then was the subject of another pit maneuver, which again was not successful by the trooper. The defendant was traveling southbound on 131, speeds approaching 90 miles an hour, crossed over the median and went on northbound 31. That's the wrong way, and ended up using one of the on-ramps to northbound 131 as a means to get onto Boone Road. Traveled down Boone Road towards a T intersection, continued down a seasonal road for a mile, came to a stop, exited his vehicle. The trooper exited his vehicle, demanded that let me back up. The defendant exited his vehicle. The trooper then came upon the vehicle, exited as well. According to the trooper, he demanded that the defendant not take steps to leave the area, or the trooper would deploy his K-9. Ultimately, it appeared to the trooper that the defendant was leaving. The trooper then deployed the K-9. The K-9 was ultimately successful in making contact with the defendant. The trooper demanded that the defendant stop and he would be released from the grip of the K-9. The K-9 had the defendant's right elbow. Eventually that did occur. After a slight struggle, the trooper was able to secure the defendant's arms behind his back and handcuff him. On cross-examination, the trooper identified that in fact the dog had clamped the right arm. Discussed when it was that the dog would be released. The trooper also identified that he had not observed any bad driving, but that he was in fact engaging in the stop in order to bring the defendant into custody pursuant to a lawful warrant. And that when the trooper released the dog, the defendant was running at that time. The defendant indicated in testimony that he was not running. He had slipped a couple of times on ice, that he had been in contact earlier before this event with the state police alleging corruption in Wexford and Missaukee County. I think by that statement, he's attempting to indicate he had a mindset believing that perhaps he was being targeted. He didn't say that. That's the implication of what I heard the testimony implying. That he was on his way to go to a body shop outside Manton when he noticed an unmarked vehicle. He was concerned about potential stalking and was worried that the unmarked vehicle was involved in stalking. The roads were icy. He was pulled over. He saw some other vehicles that were pulled over. He safely passed those vehicles. And then a marked police vehicle came up behind him, came around the unmarked vehicle that was traveling behind him as well, got in between the two vehicles and attempted to pull him over. The defendant believed he was in danger. He was trying to get to safety in Missaukee County. which is where his father lives. He called dispatch and told them to, pardon me. So he left and called dispatch and told them to have the cop slow down and pull back from the chase. The dispatch told him that the vehicle following was not going to do that. Ultimately, the witness pulled off on a 2-track, went to the dead end area, put the vehicle in park, took a few steps, slipped, and then heard the officer yell, "Stop," at which point he noticed he had a dog that had bitten into his arm. The dog clamped into his arm beyond clothing, into his skin. And on cross-examination, he indicated that he thought the trooper was reaching for a gun back when on direct as well. He indicated he thought the trooper was reaching for a gun when the trooper was pulling him over initially, or after he had pulled him over initially. And that's when the witness took off. The witness was told on cross-examination, he explained he was told he had a warrant. He indicated that he did in fact flee from the trooper, that he did break the 90-mile-an-hour marker, and that he did use an entrance ramp on northbound 131 the wrong way. So the standard of review here is a preponderance of the evidence. That is a tipping of the scales, 50% plus a little bit. The record establishes to the mind of this court that there is enough information to establish that first, the bond condition with regard to threatening or intimidating behavior has been met, in that the behavior of the defendant was certainly dangerous, threatening to people on 131. He was traveling 90 miles an hour on the right way on southbound 131, and then crossed over the median going the wrong way on 131, which could have caused a devastating accident, went up the entrance ramp onto Boone Road, which could have caused a devastating accident. He put people at risk through his driving. That is more than enough in and of itself to justify a lifting cancellation of his bond. However, there's more. There is also certainly enough evidence on the record to indicate that by a preponderance of the evidence, there is evidence here of a crime. It does appear that the defendant was properly pulled over. He was being contacted by police. The police were appropriately marked. He left the area speeding away from the police officers. That is fleeing and eluding in and of itself. That is a crime here in Michigan. And then certainly his behavior from that point until he was ultimately taken into custody also would support, in this court's mind, a finding that in fact there was a criminal activity here that would meet the criteria of a violation sufficient to violate the bond condition. So as a result, and for those reasons, I do find that the defendant has violated his bond. I also find that the appropriate place for the defendant, given that violation, is to be held until such time as we have a final conference in this matter. I'm concerned about the defendant's decision-making out in public right now. Frankly, having him in a secure location, I think makes a lot of sense given his concerns and given the threats that he has already posed by this behavior to the public. So as a result, his bond is canceled. We'll set this matter for, I think we have it set for final conference coming up here very shortly. And we'll have.
Just when the hearing appears to be finished, Mr. Mattson raises another objection. He questions the crime victim fee and again challenges the court's jurisdiction. The judge responds firmly, explaining that the court is operating under Michigan law and that the victim rights fee is required by statute following a guilty plea or verdict. With that final objection addressed, the judge prepares to end the proceeding and conclude the hearing.